Very much, Convener. Good morning, Lord President, and thank you very much for coming. The significance of what we're doing this morning is not lost, I hope, on us. And it's the constitutional issue that I actually want to pursue. You have clearly stated that you personally believe that your judges should be trained, and that's in a sense a duty on them, and you will facilitate that. What I'm wondering is whether that is something which should appear somewhere within the document that we're discussing, not necessarily at the point perhaps we've reached, whether the duty of judges to be trained is something that we should leave to yourself, or whether it's something that we should state as a requirement, as it were, from ourselves within legislation, or whether perhaps it should appear the other way around, perhaps in the considering of whether or not a judge is fit and should be removed, whether perhaps one of the grounds for doing so is a failure to be trained and a reluctance to be trained. I'm just wondering whether it should appear somewhere on the face of the document, or whether we should just leave it with yourself as Lord President to take the view that you've taken.
Well, as you're aware, of course, it does appear amongst the range of responsibilities that are imposed upon me as Lord President under Section 2.2, subparagraph D of the bill, in which I am charged with making and maintaining appropriate arrangements for, amongst other things, training. It's a question of finding the right way of securing the ultimate end. And my experience has been, on the whole, the best way of securing due performance of the sorts of things that you have in mind is by giving an appropriate encouragement to secure the attendance of judicial office holders at such matters. I think there are dangers if one uses the stick too much rather than the carrot. And I think that our judicial office holder is going to be much better able to receive useful training if he or she has been encouraged to the view that it's a good thing for him or her to go there, rather than by two policemen marching him or her to the appropriate place. So that I would be disposed to the view that the better arrangement is to leave matters to me, to put in place the appropriate arrangements. If it is necessary, then the arrangements could include matters which verge on compulsion, but I would hope it would not come to that. And I certainly would hope that it would not come to a situation in which a judge was so delinquent in relation to performance of attendance at training and the like that it would be necessary to consider his or her removal from office.
Come to the general question of vacancies and appointments. This question will be opened by John Wilson.
Good morning, gentlemen. The bill sets out the procedures to be followed in relation to the appointment of the Lord President and Lord Justice Clerk. Do you have any views, Lord Hamilton, on the provisions contained within the present bill?
I'm quite content with the arrangements as they exist in the present bill. In particular, I am quite content with an arrangement in which the body charged with making recommendations for nominees for these particular posts are as set out in terms of the bill. While perhaps there's a qualification to that, I think at one stage I did express the view, and I think I would adhere to that, that there could be an advantage in having either a judicial majority or a situation in which if it was an even board, as I think the four are envisaged at this time, that the senior judicial members should have a casting vote. I think I can't recall whether that's in the bill at the moment or not.
So you're sufficient?
Yeah, yes.